development in the United States in the criminal procedure and domestic security area. Certainly, capital punishment is it's easy to lump it with, as Carolyn Elizabeth did, abortion and the civil rights movement in the schools as interventions by the court in a grand constitutional style in issues that have huge social and political resonance. And what I thought would be maybe useful for those of you who know comparative constitutional law, and I am not one of them, but at least to contribute something to your thinking about American constitutional development in the recent times by looking at the technical cases. Yes, when I say technical, I am, I think, unfairly labeling a lot of the kinds of cases I'm trying to look at in an overview as pedestrian or boring. And obviously, when you're talking about constitutional criminal procedure, there's really no such thing as technical. One of the things hopefully we get our students to realize is at the heart of procedural rights, at the heart of what look like complex doctrinal exegesis are the liberties and we certainly can admit among us the dignity of individuals. So one thing is that the focus ends up being, and this will connect to what I'm sure Michelle will be speaking about. These are procedural cases. If you look at constitutional development in the criminal space, particularly outside the capital punishment area, you're dealing with procedure. And I want to at least problematize why they're so procedural. One of the, I think, frequent comments you hear about American constitutionalism in the criminal space is that Americans have a particular affinity for proceduralism, that we think in procedural terms, that even when we are quietly making very substantive interventions, we feel more comfortable doing it in a procedural. And that's certainly true. What I'd like to just remind us all is that there is a historical reason for that. That criminal justice was not really of constitutional significance outside the federal government until the criminal justice revolution. And that when you saw those of you who noted that the Bill of Rights wasn't necessary, well, there was no federal criminal law for the most part until very far into the country's development. And the states, which were the places where criminal justice were, they had bills of rights. They had notions of whether they called it dignity or not. They did have notions of fairness, proportionality, and the like that don't creep into federal constitutional law until very late, if at all. But part of that is because federal constitutional law did not concern itself with criminal material. And one of the nice places to watch the federal courts start to think in substantive constitutional terms, prohibition is the magic time when federal criminal power starts to really intrude in the lives of everyday American citizens. And you see the Supreme Court thinking in an interesting mix of substantive procedural terms. So this is all a very long footnote to the point that when I talk about constitutional development in recent years, they are procedural cases. It didn't have to be that way. I am not sure it will be that way in one of the questions hanging over the last discussion is what in 30 years, 40 years, when we've had about 100 years of constitutional development under the US Constitution speaking to the criminal justice system as a whole, will it be as procedurally driven as it is now? And the answer is, we'll see, and that will be an interesting question. But that said, I wanted to look at the cases we do. What do they look like? To what extent do we see the Supreme Court acting as a constitutional regulator in a very large criminal justice space. And one could imagine, particularly given the county basis of criminal justice in the United States, the very diverse nature of the institutions that practice criminal justice, that when the Supreme Court spoke, it would speak boldly, it would speak clearly, it would speak in a way that communicated in a very specific way what the federal constitutional norms would be. And you certainly have seen that in the past. You've seen that in the 60s, you saw that in the 70s. And what I was wondering is, so what does the language of constitutional regulation look like now? So I cast about. This is far less developed in an intellectual sense than Carol's piece, because Carol really has a well-developed scholarly agenda that gave her an incredibly useful lens, and Elizabeth as well, a lens to look at these cases. And I did not want a lens. I wanted to see what happens when the court encounters this mass of criminal justice being delivered. You know, there are in 2006, there were 1,132,000 felony sentences in the United States. You know, this is a huge country. And it's developed for the most part in counties, and you would think that the Supreme Court would speak in a way that at least communicated some norms. And what I thought was most interesting is not so much. And that's sort of the whole cash out of the paper, but just to explain more clearly, to make my project even more difficult, I not only looked at the general cases in the past 25 years, I wanted to look at the cases where the Supreme Court has moved forward with respect to constitutionalism. So what that puts to a side is the large number of cases where, particularly in the search and seizure area, when it comes to regulating the police, the Supreme Court has relaxed in various degrees regulation. I want to talk about sort of what are the technologies of advancing the constitutional project in the criminal justice area. And what I found is, I thought kind of interesting. I found that there are a few very sustained rights projects that the court has developed, that these projects have, and this will connect to what I think that Michelle will be talking about, been very closely tied to nakedly procedural rights in the Constitution that have allowed an interesting coalescence between those who would develop the rights project more generally and the originalists and formalists like Scalia who are looking for some core protections to develop. So we have these very interesting, and I know many of you haven't read the paper because it hasn't been widely circulated, but if you look at sort of the right to confront the witnesses against you, or the right to have a jury pass on the elements of the crime. These two very technical pieces were developed by the courts in a long line of cases to be this very elaborate edifice that highly regulated the way hearsay statements could be introduced in criminal prosecutions, that highly regulated the way in which state legislatures could tie the hands of judges in what kinds of sentences were passed. And the Supreme Court sort of works through these cases over basically 10 years, coming back year after year to take one more, to add to this development, to the accomplishment of, I think, not that much. It's almost as if, to be incredibly nasty, the Supreme Court is paid by the doctrine enunciation and it doesn't matter how many cases or how many lives they affect. They seem to have a quota that can be easily, this is not the way I put it in the paper because it's flip. But it seems to be a quota that can be satisfied by just creating law, but by writing cases that really leave completely untouched most of the criminal justice system in the United States. Most of the criminal justice system in the United States is plea bargaining. Plea bargaining remains underregulated. I expect will remain underregulated for quite some time. And interestingly enough, and I picked a few cases just to show a variation in the way the court deals with doctrinal enunciation. When the court moves to plea bargaining, as it has been in recent years, it's not in the highly developed constitutional elaboration mode that we saw when they were dealing with the confrontation clause, when they're dealing with the balance of power between sentencing judges and juries. It's with I called it posters in the marketplace, in the sense that it's almost like an acknowledgement that there is commerce being done, that commerce is driving the American criminal justice system in a way that is relatively untouched by the elaborate doctrinal work that they've done in those few formalist cases. And even as the Supreme Court has made a few regulatory interventions in recent years, and made those interventions in the context of a recognition that plea bargaining is the way we run our adjudicative process, it's very pointed. It is very unambitious. It is practical. It is not rooted in originalism, which of course means that this is a very different kind of case than the ones that I started with. But they are, and it's a different set of justices. And it doesn't move us very far towards a constitutionalization of the sort one might expect if one looked at the broad rhetoric in the confrontation clause cases that the court did so much work in. So what I want you just to look at as compared to this is that the Supreme Court is not very ambitious at all. And let's put aside capital punishment because we've discussed that. But in these million cases that go forward, to what extent are they regulated by the Supreme Court? The answer is very little. When they do their work, when they very forcefully articulate clear constitutional norms, it's with respect to a very small minority of the kinds of criminal justice issues that emerge in the regular run-of-the-mill case. In plea bargaining, they will watch from afar, and in those cases where they're most likely to start deploying broad themes of dignity, of privacy, and the like, and this is the third kind of case I identified, it seems to be with an eye to fitting in with what other institutions are doing, with an eye to fitting into where the executive and legislative branches are moving with respect to DNA technology or digital privacy. The court is ready to think in terms, and this will connect to our last discussion of dignity, they're ready to think in dignity and privacy terms when they are collaborating with other institutions. When they want to act by themselves unilaterally, you're much more likely, and this is why I say lack of ambition, when they act unilaterally, this is where they're going to be closely tied to explicit constitutional authorizations. The dignity is their conversational gambit in the privacy area. And I thought a perfect case for me is not in the paper because it was decided Thursday, which fits perfectly into the conversation. So the case on Thursday is Riley against California. Here's a little brief constitutional law. yes, we have a warrant clause in the United States that requires kind of, sort of, that searches and seizures be done only on the basis of probable cause and, if possible, judicial authorization. One huge exception to that was was searches incident to arrest. When you arrest somebody, you get to look through his stuff. Is sort of the general rule in American Fourth Amendment. So the question that comes up, so if it's in his pocket, you can look through his pocket, you can do all sorts of relatively invasive things constitutionally when somebody's arrested. So what happens when what he has is a cell phone? It's in his pocket. If it were an address book, you probably would have been able to open it and look through it. Well, is a cell phone just like an address book? Is a cell phone like pocket litter, the things that one can find in somebody's pocket? And what's interesting is the court's pretty sure it's not. The court, and I say pretty sure to give the tone of tentativeness that's involved in this whole opinion, they're pretty sure that it's really different, and certainly in this case, it's not going to be permitted. As they start to explain why they're not going to be permitted and what the lines are going to be, you start to see how a recognition of they're moving into an area where they're not in full control, where they're going to try to fit into an ongoing policy conversation seems to be driving the opinion. There is this effort to acknowledge that there might be cases where we might want to ensure that the police are able to access a cell phone and here you see a remarkable amount of practicality. They're beginning to realize that you could set up your cell phone so that it can shut down or can erase itself if you move out of certain geographic zones. And the court's sort of working this out. They know they don't have all the facts. They know that we need to have some constitutional boundary setting here. But this is a style that I think is probably, I think, the most characteristic of the Supreme Court in the criminal procedure area, outside the capital punishment area, and outside the areas where they're doing very close interpretation of explicit constitutional provisions. They are very self-conscious in their moving forward, laying down some norms. This is where you're probably most likely to find allusions to dignity, privacy, to squishy concepts that we recognize in the United States, but that don't have the kind of clarity that can support hardcore judicial intervention in a unilateral way. When they act collaboratively, that's where I think values can be most clearly articulated, and I expect we'll see more and more of this in this collaborative project. Just to sort of go back to the conversation we were having in the last session, and I'll end with this. On one hand, you could say that the United States is sort of dignity starved. That dignity and grand notions of fairness, proportionality, all of these substantive values are ones that we have, for the most part, through our constitutional development, shied away from relying on. That might be true, or you could flip it and say that our courts have gained their purchase and their power to intervene in the constitutional space, particularly in the criminal justice area, which, and this goes back to our discussion of counties, isn't highly constitutionalized, is highly American, is quintessentially democratic, but has not been highly constitutionalized, and the court has gained its interventional power in the criminal justice area through reliance on what look like and what sometimes sound like very proceduralized values. Having gained that purchase in that space, having gained this ability to really speak forcefully when necessary to this entire very varied criminal justice world, then the court is a little more free to draw on the broader concepts of proportionality, privacy, and dignity. And as they have this confidence, you can expect it more, but when they move into new areas, you should expect them to be looking at all times over their shoulders, because they really do not see themselves, and I don't think they should, and that will be normative, I don't think they should see themselves as being the pathfinders as we're working our way through balances in newer worlds.
Thanks.
Okay, so my job is very difficult because you're the expert and I'm not. So I certainly cannot go into the little I know about these cases, and some of them have appeared on my radar, because I should tell our French colleagues that due to an anomaly of dividing the subject, even though criminal procedure rights are within the Constitution and the Bill of Rights, those of us who teach regular constitutional law never look at them. So I have no expertise, even though it's part of my field. I will start with one thing that strikes me about your paper, and and you've mentioned it yourself, but I'm trying perhaps to speculate beyond that. And that is the clear contrast between plea bargaining, which seems to be absolutely essential in terms of the number of cases. Many more people may end up with plea bargaining, which seems much under-constitutionalized, versus these other areas such as confrontation clause and whether sentencing guidelines and how much the jury should say, how much the judge should say, and all these controversies. And Breyer was on the sentencing commission and he's complaining about it. So we even those of us outside the criminal procedure area know about that. And I'm puzzled by this. And one hypothesis I'll put on the table, hopefully for you to react perhaps vehemently, good, if I'm totally wrong, is the idea that we look at the whole criminal process with disdain, in a sense. Yes, we do have the Bill of Rights, but when they take polls, people are happy to abolish it because it's only, as my criminal law procedure professor said centuries ago, don't forget, he was on the right, even though I was in law school in the era of civil rights, and says, you're talking about the hoodlums.
Talking about what?
Hoodlums, les voyous. And so the idea is you bleeding heart liberals want every little technicality to be taken care of and vote the Constitution, and you have these beautiful clauses, but in effect we're dealing with a population that only hurts us, demoralizes us, etc. So one way to look at this is we want to tell the world how we in the United States are above all this. We're constitutionally involved. We have a fair system, adversary system of justice. Everybody gets to say what they want. So if the confrontation clause looks askew in any way, we're going to make sure there's a decision of the Supreme Court. In the meantime, we're sending all these people who are caught, who don't have a lawyer or have a lawyer that is brought and who has 15 cases a day, doesn't sleep at night, and they're locked for 20 years. The state doesn't have to have a trial, no company, and so forth. Okay, so this is interesting. If it's true, it's an interesting sociological fact about how we deal with crimes, and would show why we have this complete dichotomy. The second, and here I'm going to quickly exit from your area of expertise, and it's for me, when I read you, and you have those 3 points, which at the very beginning, and I followed them carefully as I was reading your paper. You divide into 3. One, elaborately articulates doctrine, but either by design or effect occupies a small field. So the Supreme Court is assertive, you get a clear result, but the effect is going to be minimal. Second, takes a far larger regulatory subject, but takes extreme care to limit the scope of its intervention. So here it speaks with a big voice, but it only applies in 1 in 1,000. Again, no effect. And third, seems to have sweeping structural ambitions, reminiscent of the Warren Court criminal procedure revolution, yet entails considerable reliance on collaboration with other regulatory authorities. So if the executive or the legislative have made a lot of noise, we join and applaud. I want to come out of your area here because what made me your paper, besides learning a lot of interesting stuff that I didn't know, and I thank you for that, I wanted to see are the areas that I deal with in any way, do they in any way fit here? And my general conclusion is no. The years that we have are 1990 to 2010. And I'm going to go out of the criminal law area, although I'll touch on the security area because there have been a series of cases. In that decade, we have U.S. versus Lopez, who changed the Commerce Clause jurisprudence. From the New Deal to 1995, the federal government had, in effect, a free hand in regulating commerce. I mean, economic regulation, economic social regulation that involved any national problem. In 1995, the Supreme Court, in a case involving, which by the way was not a very sexy case for the Supreme Court to come up with this decision. It was a guy who brought a gun to a school in Texas. There's almost certainty that the gun was manufactured outside of Texas. And he brought it to give it to his friends who were in a gang. And there is a tremendous problem with violence in the schools. Billions of dollars are lost in terms of time, injuries, teachers not being able to focus on education. But the court said 5-4, a gun and bringing them to school is not a commercial activity. Up until that point, the Commerce Clause, which was devised in the 18th century, which was supposed to regulate commerce between states and commerce between the United States and international nations, and leave outside the Indian tribes, which were also involved in the Commerce Clause. But so it was international business and business in the states, had been interpreted after the New Deal that anything that's local but has a national impact, and you multiply the instances. The famous case, the case of the one guy who grew too much wheat under a wheat quota in his farm in Ohio, but the court said if every farmer in Ohio does the same thing, then it'll have an impact on the price of wheat. So we were in an era where anything that had to do with commerce, the Congress had a free hand, and the states had nothing to say. But in Lopez, the Supreme Court changed that and said this gun is not used for commercial purpose, and you must have some kind of commercial activity in order for Congress to retain that right. That's huge. Now people said it's not that big, only a few things will be affected. But it's huge, and the next case shows that these are not small incremental steps, but that huge revolution. That was, I mentioned this case to some of you during the break, was the Morrison case, U.S. versus Morrison, and the Violence Against Women's Act. Congress had enacted a law on the basis that state law were insufficient to deal with the problem of violence, and short of rape, but other forms of sexual violence against women. And this law was particularly noteworthy because 38 of the state attorney generals had backed the law. And there was enormous state backing for the law, and on the level, I think the Senate was 99-1 in favor of the law, in the House also, a very huge majority. The law is enacted, and we have and again, statistics were provided, because this was after Lopez, and one of the problems with Lopez is that the Congress was sloppy and didn't state how many businesses were affected and how many billions of dollars were lost because of guns in schools. Here, there's a huge amount of statistics. Women don't travel. They're discouraged from going to business. Rape and threats of rape disrupt education, disrupt businesses. It's a huge, if you accumulate, it's a huge problem. And the court, nonetheless, again 5-4, said violation, sexual harassment, violation, violence, etc., is not commercial. Which the dissenting justices were very rather impatient and acerbic. Breyer said, so it turns out that if a woman is beaten to take away from her sandwich, because otherwise you have to buy a sandwich, so that would be considered a commercial activity, then Congress could regulate that. But if she's simply raped or she's simply beaten, you can't, because there's no commercial underpinning to that. So again, a huge impact on the changing landscape. Let me mention a few other areas where there has been quite a bit. Perhaps the most remarkable case in all of this, because it led to, in effect, the decision of an election, and it is within the 1990 to 2010 period, right in the middle there, Bush v. Gore, where again, 5-4, the Supreme Court decided George Bush won the 2000 election. They're all kind of doctrinal and constitutional subtleties, which I will spare you, even though they're interesting and can be parsed out in different ways. And then let me conclude with, already we've mentioned the shift in the Supreme Court in terms of the discrimination against homosexual, sexual orientation cases, and that we're maybe heading to recognition of same-sex marriage. We're not there yet, but there's a very quick evolution. So let me mention the terrorism cases. And here, interestingly enough, the Supreme Court, and many have been, including myself, critical of the results of not going far enough, but the Supreme Court has been quite assertive against first the Bush administration. I'm talking about the cases such as Rasool v. Bush, Hamdi decided in 2004, then Hamdan and Boumediene. And it has in part relied on institutional arguments that the president was doing things like establishing special courts without the backing of Congress. So if Congress and the president aligned themselves, then there would be more legitimacy. But in Boumediene, the Congress did align itself with the president, and nonetheless the court struck that down. So the court struck down a series of cases on the basis that there are some fundamental rights, basically due process and habeas corpus rights, that even somebody who is labeled an enemy combatant preserves, notwithstanding all the threats of terrorism and the fear that we were going to repeat 9/11 at some point. Okay, these are just examples, but I want to draw a larger point, and in view of the discussion, both specific discussion about criminal procedure, where in fact, to my view, it's quite remarkable that what you find is so different from what I find in those 2 decades. And obviously there are ups and downs in other cases, I'm painting this very broadly. But I find that the court, there's a lot of literature on the fact that the court follows public opinion. Barry Friedman has written on this and others. And interestingly enough, if you look at a little broader than 1990 to 2010, you look at one area today also, which I should mention, is the area of this whole area about money in elections, the Citizens United, and this term, I think it's McCutcheon decision, where the court seems to allow for as much money as possible in elections, which many people have called the total distortion of the democratic, or potentially distortion of the democratic process. So the Supreme Court has injected itself in some vital areas of American political life and institutional life, and had some very dramatic decisions that are impossible to overturn, in the sense that there's not enough politically it's impossible to think of a constitutional amendment, which is the only way that this could be overcome. What is happening? Now, to some extent, the court is following more or less public opinion. I think in its evolution in the area of sexual orientation rights, the court is very much, perhaps a little behind the polls, but it's following in that direction. But in other areas, it's very difficult to say whether it is or it isn't. My sense is that Citizens United, that there was, not only did Obama speak against the State of the Union message, but that most people, and I haven't seen a scientific polling of this, but at least anecdotally, it seems a lot of people tend to believe that politics are corrupt, and the more money you throw at politics, the more corrupt it will get. So my sense is that probably it's not following directly public opinion in that area. And perhaps the area in which there is the greatest dissonance is the area of abortion. What happened after Roe v. Wade, and continues to be, is that the country is extremely divided over the jurisprudence of the court. Now, the majority of Americans do support abortion rights with all kinds of qualifications, but there's an enormous amount of tension and fraction over this. And one can say that the court has injected itself, and many have argued that they should not have decided since there was no textual basis for the decision, they should not have decided the abortion issue, should have left it to democracy, or should have left it much more time to democracy. So, to make a long story short, my sense is that the Supreme Court in many areas is doing some very dramatic work. There are many ways we could look at it and there's a very complex relation in terms of the federalism aspects of its decisions, because they always have, to me at least, two dimensions. One is there's a genuine ongoing debate about how much money, how much power should be centralized in the national government, how much should devolve to the states, and this has been a tug of war since the 18th century. But there's another dimension of this which has to do with specific politics. What are called state rights, which is a misnomer, it's really state powers. States don't have rights, they have powers, is often a code word for something else. The entire civil rights era, states, what was called state rights, was a resistance to racial integration, to civil rights, to voting rights. What is interesting today, state rights in another great area of contention where the court spoke with a 5-4 decision, where it did not destroy the Affordable Care Act, which is a reform of the health system that Obama put forth, but it greatly weakened it to its jurisprudence. Is states' rights has been a standing in for those states that are against this, again, to be quick, we'll call greater socialization of medicine, although it has nothing to do with the systems of medical insurance you have in Europe. Many states, the states that are against it, in effect represent a particular view, which is usually the view of the Republican Party and the more conservative, libertarian political forces within the United States. So you have the alliance of that wing of the political spectrum with the state rights rhetoric, and the Supreme Court having intervened, having technically upheld the law, but having much weakened it by allowing states to go away from the, under one clause of the Constitution, the federal government can spend money and give money to the states and exact certain conditions. But for the first time, the court went very far in trying to limit the kind of conditions that the federal government can impose on the states, which has led to many states defecting and which has led to undermining, to some extent, the whole project. So, my conclusion is, things from the other side, meaning from a non-criminal jurisprudence, look quite different than from what I read in your excellent and informative paper.
Can I have this button? Thank you. Thank you. And think of it this way, and you know, it's interesting what cases you speak of. In the United States, to the extent the Supreme Court is going to intervene in the criminal justice system writ large, particularly on the state side, its interventions, I think, have tended to be limited and robust in the sense of it will speak without expectation or likelihood of response. Outside of the state area, when you're dealing with the federal criminal justice system or the federal system more generally, the Supreme Court ends up being, particularly in an area like security, where the legislative and executive branches are not going to abandon the field. They will be back. It very much, whether it likes it or not, is engaging in a conversation. So therefore, when you look at a case like Lopez, from the context of Commerce Clause jurisprudence, it looks like an important case. When you look at it as a criminal law case, it is meaningless. Within a few days, Congress comes back, passes the same statute with a Commerce Clause hook, and life moves on. Morrison, meaningless. All you need to do is travel in interstate commerce to commit a crime of domestic violence, And if they choose, the federal government can prosecute you. They
Use a
generally
computer or a phone.
right, and so these are speed bumps in the criminal system, because when you have an interest on the part of the political branches to move forward, the Supreme Court's cases, to the extent they're pointed, like Morrison and Lopez, end up being very much like my first kind of cases that are little elaborate miniatures. That's all Lopez is in federal criminal law. Outside, and it's interesting when you talk about the terrorism cases, when you talk about the Guantanamo cases, I was thinking of, although it would have made this much longer, writing about them in the third section. It looks like when you look at individual cases in the security, and the Supreme Court boldly moves into curtail executive power. They've done nothing of that sort. They boldly moved in with a few pronouncements and have largely not abandoned the field. The lower courts are working out what we mean in detainee law. The Supreme Court will make sure not to touch that for quite some time. They will both. So the Supreme Court has opened up this space for business, but has not participated in the business itself for quite some time, and maybe they will in the next few years, maybe not. But I think Guantanamo and the terrorism cases are the quintessential example of collaboration with the court using broad rhetoric, but being quite careful about creating a robust regulatory framework. So, I mean, I think you've pushed me really nicely to think through why it is that we have these types of cases in the security area, and it's less about the court and more about their interlocutors. It's more about the readiness of the political branches, and this will be particularly in the federal system where you can have coordination and a real engagement of conversation. The court, when it has interlocutors, is particularly, if not careful, at least aware of its involvement in a conversation that will go on and where they can only contribute, not dictate.
If I could just have a comment on this, what this evokes in me, your response, is that in effect, and this was, I think, confirmed my initial intuition reading your paper, is that a lot of what happens in the criminal law is to make us feel good. We, the outsiders, should know that we have a confrontation clause, we have this. Hamdi had that. Hamdi was let go because they had nothing. Right. In 3 weeks, they let him go back to Saudi Arabia. But he has real rights. And then it's business, even Lopez, business as usual. However, in the areas that I'm speaking, in terms of commerce, the sort of what I call the potential evisceration of the Affordable Care Act would have been impossible without Lopez. You
Correct, that's exactly right.
And Lochner was a huge problem for Franklin Delano Roosevelt until the series of decisions that got rid of it. So it's interesting that in areas in which there is major political strife, and where the court comes in and does move the post, does do something that furthers certain agenda at the expense of others, this is very important and may change the constitutional landscape. For some reason, we don't care about criminals, basically. And we really don't. I mean, this is true, and I must feel bad for confessing myself. I don't follow every Guantanamo prisoner, what is happening to his case. I can read these cases, I can teach them to my class, I can feel like a nice liberal professor. In the United States we have the rule of law, but there may be hundreds of people going to the lower courts, as you point out. Nobody pays any attention. The lower courts, I'm sure, pay lip service to the Supreme Court, but it's a totally different day-to-day story. So that's an interesting, I think, gloss on the whole thing. Where things are politically intense and the Supreme Court speaks out, and sometimes is persistent, even when they're not following, at least they're not following the polls that closely, then we have a lot of strife and a lot of debate. Otherwise, we may feel good or feel bad about the decision, but we forget.
Let me intervene, because Florence, you have to go to your dissertation defense. So I'm going to take over as chair before passing it to Michel for this afternoon session. And immediately abuse my prerogative by intervening.
Waste no
That's
time.
what power is for.
Exactly. Okay. So one thing that's this conversation makes me think also, in your paper, is the 1960s, the Warren Court, intervention in the criminal procedure area is a foil here in a certain sense, right? Now, is it or is it not? Okay, so this raises a couple of questions. One could view that period as having been a period where the court was trying to radically alter in a large structural regulatory way the whole field, right? So very different than these three brush strokes, very different. Merci Florence.
Merci à vous.
Okay.
Ciao, ciao.
You could say, though, that the impact was negligible again, right? So you've got the Miranda decision, which we could tout as a Lopez case, but then we've got all of the literature and the empirical literature that suggests that Miranda really didn't change anything whatsoever, right? So either it's a foil that did have an enormous effect, or a foil that, like your cases, had no effect. But if it was a different time, one question that one could ask is whether these are strategic, whether there's an underlying strategy beneath having these three brush strokes, which is to really, the strategy, we know that the Rehnquist court wanted to withdraw from many of these procedural innovations. Could it be that what we have here is a strategy of taking confrontation cases that are meaningless because everybody's pleading out, right? So it looks as if we're doing work, but actually the strategy is to do that, right? These are strategically deployed. And then that raises the question, right, but then why do they keep taking these criminal procedure cases? Right? And so that has to do a little bit with the work from that I have, Owens and Simon's graphs and numbers and calculations, right? So criminal procedure becomes more important in the common era here because the court is limiting its other cases but not limiting its criminal procedure cases. If one were thinking that they were strategically trying to simply get out of the field or not regulate, then why is it that they would even continue to take the cases? Wouldn't a better strategy simply be to not grant cert, in our area of interest? Carol, you want to jump in?
Yeah, I want to jump in on precisely that point because I think it's a mistake to think about strategy here because the court is so fractured in its approach to criminal procedure. So, when you look at, for example, the Apprendi and the Crawford revolutions, they arose out of this weird coalition between the originalist justices who think that there's some, textual meaning of confrontation, or Sixth Amendment right to, jury determinations of fact, joined with the liberals who want to just give a little bit to the defendants and give them another bargaining chip at the plea bargaining table. And, to think of strategy in that context, it's like they're talking completely different languages and have completely different agendas. So it's like weird coalitions and bedfellows in a lot of these cases make it, I think, very hard to think of this as a concerted Supreme Court strategy. I do think the question, though, is why is the criminal justice system so impervious to change? And I think your first question, is the criminal procedure revolution a foil or just another part of the story? Like all the police practices stuff, the police, it's like Teflon. You give them Miranda, give them lemons, they make lemonade. Miranda's great, and they make it work. And
don't they need to have a dialogue with the states?
yeah, but I think this is an example where the Supreme Court spoke boldly, but filtering it through existing institutions kind of changed the kind of meaning of the rule. I'm trying to think of, and even we think of things like Gideon, which we just celebrated the 50th anniversary of, that was really a case where there were only a few outliers who hadn't already, given rights to counsel. And so the Supreme Court was just completing a revolution that had already occurred. So I'm trying to think if there's anything that happened in the 60s that was not about to happen anyway, that really made a huge impact. Matt was thought to make a huge impact, but nothing ever gets suppressed. So that
Matt gets suppressed after Matt.
well, very little. Yeah.
Carol, slightly overstating it because
come on.
she's been in enough cases where
I mean, I have to say, I practiced as a public defender for 4 years, and of thousands of suppression motions that my office filed, the numbers that actually succeeded could be counted probably on 2 hands. So, and that's one of the best public defender offices in the country. So if our rate of achieving suppression, constitutional suppression, was indicative of, suppression in general, then I don't know if it was ever happening. It sure wasn't happening by the time I was a public defender. What do you think, Dan?
Well, I mean, you hear very different stories about exactly this from Carol and from me because, from the defense side, the most salient things are how this constitutional norm is not prevailing enough. She's very much aware of cases where, it looks like the police very much acted unconstitutionally, and said to say, we'll get away with it. I was on the prosecution side, and the story from the prosecution side is, well, we're really scared of
Really?
Yeah. Maybe I was in one of those minority of good offices, but I don't think so. I think if you talk to police,
You were in the federal system,
Yes.
which is different.
that's where I was going next.
And you were in
It's-
the Southern District of New York.
Right. It was a snooty place where we tried to obey the law, which maybe puts us in the minority.
And that's the thing, the kinds of things that happen on the, in sort of street level law
Yeah.
enforcement was just a different. You were dealing with the FBI, the DEA, the ATF. We were dealing with the Metropolitan Police Department.
Right.
It's different.
Perfect dual federalism.
Yeah.
But that
Yeah.
also, it's totally, outside our discussion, but that says a lot about the reality, the substance of federalism. Federalism is a matter of execution, not a matter of laws, not a matter of dividing between competence, but it's a matter of execution.
What do you mean by execution?
Execution in the sense of the responsibilities of the executive branch and of the executive power. The true difference between Europe and America lies precisely in that difference. That in Europe we have an approach to federalism that is very much designed after the German Constitution. As you know, in the German Constitution, you have this key notion that was invented under the Weimar Republic, but even further down, after the Grundgesetz, you have this notion of cooperative federalismus, meaning that the states must come in help of the Bund, they must come in help of the federal government, which is totally foreign to the American way of thinking.
State
And I
administrative
think
agency.
I was extremely interested in this dialogue between Carol and Neil, because it shows very much, the reason why the French are so afraid of federalism. Because this is, no, we are very afraid of federalism because it's exactly the resurrection of the Ancien Régime. It's exactly the resurrection of Ancien Régime for us. Strictly as a matter of execution. You had this majesty of les lois du roi, les lois du roi. Now they were supposed to make everybody obey. Si veut le roi, si veut la loi, everybody was supposed to say, yes, Your Majesty. Well, meanwhile, in the provinces, everybody was resisting and not applying what the laws said.
There's a great story of a very well-known capital defense lawyer who still practices in the South in the United States.
Yeah.
And he tells of a case where he had the law Supreme Court law totally on his side in a case in this little state court, this is Steve Bright's story, before an elected local judge, and he said, and the judge rules against him, and he's holding the Supreme Court opinion. He said, but Your Honor, the Supreme Court said exactly that I must win. You are going to be reversed if you don't rule in my favor. And the judge apparently said to him, son, the Supreme Court overrules me about once every 10 years. But I overrule the Supreme Court every day.
That's very fun.
Captures,
Very
I have a sort of question. I mean, part of what you were describing, for instance, this opinion about terrorism, as you said, even more than about criminal law and criminal procedure, were decision about the role of the president. I read these things mostly from a German perspective as Organstreit, as a conflict between the judiciary and the presidency. That's a very important aspect. It's not criminal law. Criminal law may be involved somehow, but on the other hand, I think that there is not only, as Elizabeth said, this very specific American structure of federalism, there is another difference between the American mechanism of constitutional adjudication and what it exists in Italy, in Germany, and now also in France. The fact is that questions to our constitutional court are sent by judges, not by litigants. And the judges are very willing to obey the constitutional court because they are a counterpower vis-a-vis the legislature. They don't want to obey the legislature, they want to obey the court. That's not at all your structure. Not the judges are sanctioned by the Supreme Court when it's reversed. So there is no clear alliance between judges and Supreme Court. You know, the court protects citizens vis-a-vis judges because this is an appellate jurisdiction. Our system is the litigants have a marginal role. The questions are sent by the judges, here in this country by the high jurisdiction. So before a legal decision. So there is a stronger alliance between the judiciary and the constitutional court. So, because your judges do not obey often. Now, in Italy, the judges always obey. They are very willing to obey because they said, we think it's unconstitutional. So if the court says you're right, immediately they will not enforce the statute. And that's maybe interesting from a comparative perspective.
I think that helps answer Bernard's question. It is this really interesting fact that here's a court that doesn't seem to want to really take control of the criminal justice system, but keeps taking criminal cases, seems to specialize in criminal, and it feels very at home in the process. How do these two things get reconciled? And part of it is exactly what you put your finger on, the way our cases arise. You're going to have, the secret at the Supreme Court is, if the state loses, there's a very good chance the Supreme Court will take the case.
You're not a court of error except when the state loses.
So you have these, judges are doing their thing, appellate courts in the various states are doing their thing, with, as you say, varying degrees of correspondence to what the Supreme Court would say were it deciding the case. And on this radar screen, there'll be a lot of spots coming up of courts that are ruling in ways that prosecutors of the state feel aggrieved by, and they will be pushing the agenda, and maybe the cases they take. This is, again, capital punishment, exception. The court, for all its sins, at least knows that they should be focusing on capital cases reasonably. And I'm being vague because it
They take
varies.
as many capital cases to slap down the Sixth and Ninth
Right.
Circuits
Yes.
as they do to slap down the Fifth Circuit.
Right.
But I think your docket control point is a really interesting one. You know that famous New Yorker poster that shows how the map of the United States looks to someone from New York? So New York is gigantic, and then there's like the entire rest of the country is here, and then Europe is over here. It's like a famous cover about the distortion of what the world looks like to a New Yorker. There's what the criminal justice system looks like to the Supreme Court. If you looked just at the docket, like which cases the Supreme Court grants on, if you look at the United States, we have 2.3 million people in prisons and jails. We have 3,000 people on death row. But if you were a Martian and you looked at the Supreme Court's docket, you'd think, okay, most of the cases in the United States are capital cases. That'd be your first thought, which would be completely wrong. Most of the cases in the United States are federal cases, which would also be completely wrong. So there's a way in which the court's interventions, cert grants, are not at all reflective of what's actually happening. Most of the cases go to trial, which is, we know, to be completely wrong. So there's an interesting way in which docket selection of cert grants reflect already an incredible distortion of what's happening.
And for those who aren't as familiar, it's about 95% of cases are played out?
Yeah.
More than that.
More than
Yeah,
that.
it
So
varies.
95% of cases
77,
don't go to trial. They're just pled out. The way you have the what's it called here? The new
Plaider coupable.
Pardon?
Plaider coupable.
Plaider coupable, yeah, 95%. But
Do we have anything to eat?
yes, it's good. So let's stop now. That was good. That was good. That was both procedural and substantive, right? Yeah. Okay. When we come back, then Danny will respond to the question. Then we'll have a small discussion before going to the next panel. When we come back, to the question of whether or not this is a phenomenon of kind of a rupture around 1980 or something, such that there would have been, was it a large regulatory mechanism before, and now we have 3 paintbrushes, or was it always that way, or should we
Must
think
it
of it?
always be that way?
Right, yeah, okay, so we'll pick up there, but let's break for lunch. Thank you. Now,